I'm Ted Shaw. I have the honor of introducing our moderator, someone who really needs no introduction in this forum, but it's an honor to do so nonetheless. Goodwin Liu, who is Associate Justice of the Supreme Court of California, is no stranger to ACS. I was thinking as I was preparing for this task about when I first met Goodwin Liu, and frankly, I can't remember. But I've known him for a little while now, and nonetheless, I went, as we all do in this day and age, to Wikipedia and learned a few more things. You know, if you look at Wikipedia, it will tell you about how Goodwin Liu was born in Georgia and spent his early years in Florida before his family moved to Sacramento, California. How he went on to Stanford, where he majored in biology. I think he was probably, at that time, although I haven't asked him, thinking about walking in his father's footsteps. But of course, somewhere along the line, he made a turn in his path after being a Rhodes Scholar at Oxford, on to Yale Law School, where he excelled. And you know the rest of the story. O'Melveny and Myers, a clerkship with David Tatel, with Ruth Bader Ginsburg on the Supreme Court, government service at the Department of Education, chair of the board of ACS. He's one of the individuals who has helped to build our organization. And then we know the events that took him away from Washington a few years ago, his nomination to the Ninth Circuit, and the obstruction of certain folks on a certain side of a certain political aisle. And it made me think about an illusion that will go over the heads, no doubt, of most of the people in this room, but given where I'm from, I thought of it nonetheless. Good when I thought about the great American philosopher and political observer, the late Richard Pryor, who said, "That's the politics, baby." You know, but Goodwin is irrepressible, and we know that the governor of California quickly seized upon an opportunity that opened up and appointed him to be an Associate Justice of the California Supreme Court, where he has started out in a way that just confirms what we knew about Goodwin, which is that he would make and is making an excellent judge. He understands the difference between being a judge and being an advocate, and now he's a judge. So I'm a member of the California Supreme Court, Goodwin. I'm the Supreme Court of the Bar. And I'm so glad that you are a member of the California Supreme Court. And I'm also a New Yorker, though. I lived in California for a few years, and there's this rivalry between New York and California. And I'm a New Yorker, and so I used to resist a saying that I heard over and over again, but I think it's particularly appropriate here, and it's true. As California goes, so goes the nation. And so Goodwin Liu will, we have the opportunity to have him moderate this panel today. It's an excellent panel, and I turn it over to Associate Justice of the California Supreme Court, Goodwin Liu.
Well, Thank you, Ted. I think that's the first introduction I've ever heard where my name was mentioned in the same sentence as Richard Pryor. That's a keeper. Thank you, Ted. That's a very great honor to be introduced by really one of the great lawyers and teachers and civil rights leaders of our time. So thank you. So let me begin with the requisite announcements. This panel has been approved for CLE. It's a pretty optimistic statement, actually. So if you haven't already and you need your CLE, go sign in the list outside the table. We will be talking for about an hour or so and then taking your questions from the floor. So there are some note cards or paper on the tables, and there's some people walking around. They'll collect those and then hand them to me, and I'll try to sift and ask some of your questions to the panel. And also, as a courtesy to your fellow audience members and to the panel, please mute your cell phones or turn them off. Okay. So our topic today, Courts, the Constitution, and Social Change, is a very broad one. Let me begin by introducing this very august panel. I'll do it really quickly because you have in your conference booklet the fuller bios of all the people here. But let me begin. Far to my right is David Strauss, law professor at University of Chicago, where he teaches and writes on constitutional law. In addition to being a very prolific scholar, David has been a very loyal servant in the government, as an attorney advisor at OLC, as an assistant to the Solicitor General, and a special counsel to the Senate Judiciary Committee. Nick Rosencrantz, my contemporary in law school, is now a law professor at Georgetown and also a senior fellow at the Cato Institute. He teaches and writes on a broad range of topics in constitutional law, previously served also as an attorney advisor in OLC. Next to me here is Reva Siegel, also a law professor at Yale. Her scholarship looks at legal history, popular movements, constitutional change, especially as it relates to discrimination, women's rights, and inequality. Far to my left is Jack Balkin, professor at Yale Law School, where he teaches and writes on constitutional law, free speech, and technology, many other subjects. Many of you know him as the founder of the very successful blog that bears his name, Balkanization. Olati Johnson is a professor at Columbia Law School, where she teaches legislation and civil procedure and writes about civil rights, race, and inequality. Before becoming a professor, Olati worked as Judiciary Counsel to Senator Ted Kennedy and also as a staff attorney at the NAACP Legal Defense Fund. And last but not least is Vaughn Walker, who until February of 2011 was a federal district judge in the Northern District of California and for 6 years chief judge of that district. I'll tell you that Judge Walker knows something about courts and social change because he is the judge who issued the 136-page opinion on August 4th, 2010, holding that California's ban on same-sex marriage violates the United States Constitution. All right, so we've got a great panel. Let me just try to introduce the subject a little bit. What we're going to do is spend a little bit of time looking backwards at history of the role of the courts in social change, and then we will switch gears about midway through to talk about some of the contemporary controversies that are pending in the courts right now. And in terms of history, let me kind of frame the topic by making these comments. I think we should begin with perhaps a descriptive account of history. Before we discuss what the courts should be doing, let's look at what the courts have actually done. And in this regard, I think, just to simplify matters, there have been three prominent theses about the courts and social change. One is that ever since Brown versus the Board of Education, it has been a principal tenet of political liberals that courts can bring about social change. And so in addition to Brown, the other cases that are cited in this regard include Roe versus Wade, Reynolds versus Sims, the one-person, one-vote case, the whole revolution of constitutional criminal procedure through Gideon, Miranda, Mapp versus Ohio, the attempt to abolish the death penalty in Furman, and now people look at the issues of gay rights as falling within this paradigm. A second thesis is that courts have tried to bring about social change, but they have been unsuccessful, either because courts are simply unable to manage large-scale institutional reform, so the examples would be things like school desegregation, and or the courts, when they engage in this kind of enterprise, spark a backlash. And so some of the scholarship on abortion, criminal procedure, the death penalty have looked at the backlash thesis, and I think those of you who read in this area will recognize some of the work of Gerald Rosenberg, whose book, The Hollow Hope, Can Courts Bring About Social Change, answered that question in the negative, and then more recent scholarship by Michael Klarman is roughly in this camp as well. A third view of this matter is that we need not take any strong view on whether courts have or haven't been successful at leading social change. The third view is that courts actually haven't tried very hard at all to lead social change. This is a view that says that the courts generally, roughly, come down in line with public opinion. They're neither sort of ahead or behind it, they're roughly sort of right in the middle of it. And this has been a view promoted by some who have reinterpreted Brown versus the Board of Education as actually roughly where the country was at, not really ahead of it. Loving versus Virginia, a case that occurred when 16 states only were holdouts for the basic proposition that persons of any race can marry each other. This is also, I think, a view that encapsulates some of the New Deal cases, where the courts were previously behind where the country was at and then updated themselves to where it became. And so this is one view that says that one solution to the counter-majoritarian difficulty is a kind of judicial minimalism. At most, courts can consolidate and legitimate social change, but they cannot really instigate it. Okay. So these are some different views. I want to begin with David Strauss and just ask David, which of these views, if any, have any validity? And if you could do a little comparing and contrasting with a historical perspective.
Great. Thank you very much, Goodwin, and thanks to all of you. Let me sort of answer Goodwin's question by trying to kind of revive and encapsulate a view about the role of courts in social change that I think is at some risk of getting lost. And if you'll forgive me the cliche, I'm going to call it the greatest generation view. You know, there's a lot of talk about 10 years or so ago, the 50th anniversary of the end of World War II, about the greatest generation, the generation that survived the Depression, won World War II, and then presided over the post-war American prosperity. That generation had a legal counterpart, roughly the same, roughly contemporaneous. And that generation lived through the kind of polar positions about the role of courts that Goodwin just outlined. Because that generation was recent law school graduates or beginning their law school careers during the New Deal, when the principal agent of social change was the executive branch and the legislature, and the courts not only were not leaders in social change, they were powerful opponents and obstructions. And of course, President Franklin Roosevelt declared war on the court as an effort to bring about the changes that society needed and to serve the needs of society. And a generation of lawyers grew up thinking that's what the courts did, that if they got involved at all, they obstructed social change. The first position Goodwin outlined, that courts don't know what they're doing when they deal with large-scale social issues. They don't have the competence to handle them. To the extent that they try to get involved, they lack legitimacy, that social changes have to be produced by society. When the courts try to resist them, they only undermine their own position and possibly even jeopardize the democratic basis of society. So that generation of lawyers really grew up thinking about the relationship between the courts and the political branches and social change in that way, that this was a job for people who ran for office, not for judges, and judges should stay out of the way. That's the best we could hope for. But that generation also, not all of them, but enough of them, that generation was also the generation that provided the legitimacy for Brown against Board of Education and the Civil Rights Movement. And then they saw things from the other side. Then they saw, having, this is in the course of one legal career, saw an instance in which the courts were the ones who were willing to take a step that the elected politicians were not willing to take. Now, as Goodwin said, there are debates about just how revolutionary was Brown, just how effective was Brown, and there are two sides to that issue. But there's no question that for the lawyers at that time, this was a big step that the court was taking, and it was doing it at a time when even the most rudimentary civil rights bill could not make it through Congress. And it was the courts that actually did something about the great moral sin of Jim Crow segregation. So the question is, how did that generation reconcile this change in the role of the courts and the role of the legislatures, a change that had occurred in the course of their careers? And as I said, not everyone was able to reconcile it. There were people in that generation who were nervous about Brown, who even opposed Brown precisely because of the New Deal experience. There are people who opposed Brown for other reasons, but people who in good faith thought the courts, this is the mistake that the courts in the New Deal era made. They were making it for a good cause instead of a bad cause, but still a mistake. But there were also people who thought, no, we need to understand that this is something the courts can do and ought to do. So how did they reconcile that? If you look at what those people thought, I think the thinking went something like this. Large-scale social changes in society, in the end, have to be the product of democratic politics. In the end, they have to be supervised by the branches of government that have the expertise, have the administrative ability, have the command over resources that can actually change the society. But sometimes there will be circumstances in which the elected officials cannot or will not act. And if they can't or if they won't, then the courts really do have to step into the breach. And the courts really do have to get something started. And that's what justified what the court did in Brown. That when the legislative process is blocked by inertia, by minority tactics like the filibuster, by interest group politics, that given the status quo bias of the legislative process, particularly the American legislative process in which there are many, many ways to block change, and it's very difficult to effect change, that sometimes the courts will have to act. When they act, though, and you see this in the writings and the speeches of people of the generation I'm talking about, when they act, it is absolutely imperative that as soon as possible they turn the reins back over to the legislatures and the executive branch and the elected politicians. And there was a kind of desperation in this generation, post-Brown against Board of Education, a kind of desperation for the courts to get out of the way. As soon as Congress was willing to pick up the baton, let them run with it. And this generation saw a principal role of the courts as being, make it possible for Congress to act. In fact, many of the most innovative decisions of the Warren Court, we all know the innovative ones Goodwin mentioned, Brown against the Board, the one-person, one-vote cases, the great criminal procedure cases. Many of the most innovative decisions, though, concern expanding the scope of Congress's power. Under the Commerce Clause, under Section 5 of the 14th Amendment, or Section 2 of the 15th Amendment, even under the 13th Amendment. Those are many of the most innovative decisions. And in a backhanded way, if you want testimony to the wisdom of that generation, that the changes that needed to be made in society, while the courts should initiate them, while the courts had a role to play, the courts really should be paying a lot of attention to the first opportunity they had to turn things back over the political process. If you want backhanded testimony to that wisdom, think about the Warren Court decisions that the more recent, more conservative Supreme Courts have overruled or cut back on. Have they overruled Brown? No, they have not. Have they overruled one person, one vote? No, they have not. They haven't really touched Miranda or Gideon or Wade or the other great criminal procedure cases. They haven't even overruled the school prayer decision, as unpopular and controversial as it was at the time. The big cutbacks of the recent court have come, and the overrulings have come on the Warren Court decisions that expanded the power of Congress. Under the Commerce Clause, under Section 5 of the 14th Amendment, and, maybe we'll see under Section 2 of the 15th Amendment, hope for the best, fear the worst on that score. So what you see, I think, is a direct, and in more recent times, a direct pushback, not against the idea that courts should be out there changing society, but against the idea that what courts should be doing is getting out of the way and let Congress do what it needs to do to change society. And I think high on the progressive agenda, higher even than reviving the idea that courts can prompt social change, which is an idea worth retaining for the reasons I said, higher even than that is an insistence that at all counts, when the political process is primed to change, primed to address a problem in society that needs to be addressed, that the courts should get out of the way. That was the ultimate wisdom of the greatest generation. I think we are in danger of losing it, and I think we need to revive it.
Okay, thank you, David. Jack, let me ask you the same broad question, which is, as you look back historically over the last century, how properly should the role of courts in social change be understood?
Hello, everyone. How are you this morning? I wanted to say that I often look at these questions kind of a weird way. I mean, for me, the question of whether or not courts cause social change is like asking whether the wheels on a car cause it to move forward. Well, I mean, if somebody rips off your wheels, your car is not going anywhere, my friend. On the other hand, if somebody puts the cars back on the wheels back on the car and takes out the engine, your car is not going anywhere, my friend. And if somebody puts it in reverse, it is going somewhere, but it's going backwards, not going forward. So when we think about the relationship of courts to social change, what we're really asking is what role do courts play in a much larger structure? And what we want to do is we want to look at the various components. So let me give you a wonderful example of social change over the last 30, 35 years. The courts have been heavily involved in social change. I don't know if you know this. Over the last 30 to 35 years, I know that many of you here think that hasn't happened, but it really has. It's all been on the right. There's been an enormous amount of living constitutionalism going on over the last 30, 35 years. It's all the right's living constitutionalism. It's keeping up with society as envisioned by conservative politicians and conservative mobilizations. Well, what have conservatives done? Why have they been so successful in using the courts to affect social change? Because the courts haven't been the major operators. They're only the most salient actors, but they're not the most central. If you look, what you'll see mobilization in legislation. You'll see the creation of civil society organizations. You'll see the creation of various forms of intellectuals and think tanks that go outside the university, the increasing number of conservative intellectuals within the academy. You'll see litigation campaigns, well-funded litigation campaigns. You'll see a concerted effort to engage in forms of direct political action and social protest. And think of the Tea Party. You'll also see examples of litigation campaigns that are connected to what's going on with the party system. That is to say, the party, in this case the Republican Party, has been taken over by movement conservatism, and the party then has worked and interacted with litigation campaigns. Also, the presidential leadership has been extremely important in nominating people to the bench and also providing a sympathetic bench before which litigation claims can be brought. Now, if you put all of these different things together, you see that the judges in this story are like the wheels on the car. They're not everything, they're important, but they're not the engine. The engine is all these other features of civil society, especially the party system and the presidency. The third thing I want to say is, even though, in fact, the dominant gravitational force, if you will, of social change in the courts has been to the right for the last 35 years, right? The reason for this has to do with larger trends in American politics. We happen to be living in what I think are the last days of the constitutional regime that really begins in 1980 with the election of Ronald Reagan. That regime is sort of sputtering out and it's gradually dying out. One of the reasons we know that's happening is because the inheritors of that regime are becoming increasingly radical. That is, and their views are becoming increasingly out of touch with most of America. This is exactly, by the way, I have to tell you what happened with the New Deal civil rights regime as we went through the 1970s. This is really what leads to the creation of the Reagan regime. So that regime is on its way out, and you might ask yourself, if you were a progressive, if you were a liberal, I'm a liberal, what would you do in preparation for this change, which is coming and is not going to be here tomorrow? What you would do is you would think about the development of ideas. You would think about the creation of direct action. You would think about litigation campaigns. And the reason why litigation campaigns still remain important, even when the courts are not in your favor, is because you need to keep placing issues before the courts so they have to consider them, even if, in fact, they're not going to rule in your favor. The classic example, by the way, is Charles Epps' book on the rights revolution, where he compares what happened in India, in Canada, Great Britain, and the United States. And he noted a very interesting fact. Beginning in the 1970s, the courts in the United States start becoming much more conservative. But what's interesting is that some social movements, in fact, the movement for women's equality, actually made many gains during the very period in which courts were becoming more conservative. And Epps asked, why is that? And the answer he gave is that an infrastructure of progressive activism was created. There was direct action, there was political mobilization in legislatures, there was mobilization at the state level, and there was also the work of people like Ruth Bader Ginsburg creating a litigation campaign that kept pushing and kept putting issues about equality for women before the courts. And eventually what happened was the courts, which aren't the whole story but are part of the story, responded in an interesting way. Not as much as Ginsburg wanted, but significantly in certain ways. So the message I want to offer you for people who are liberals and progressives is you live now in a constitutional regime which is largely slanted against your interests. It's largely a series of impediments to what you want to do. But even in such a period, you can prepare for a different world in which you can actually make a difference. Courts are only the wheels on that car. You need to work on the engine.
Let me ask, let me ask Judge Walker, are you only a wheel on the car?
Well,
Are we only wheels?
Isn't it nice to be thought of as a big wheel? Well, I wish I could spark some controversy by disagreeing with what has been said here. Of the three propositions that our moderator set forth at the very beginning of our discussion, one can find evidence to support all three of those propositions. I think all three of them are true. That courts do not lead social change, they lag behind, and sometimes are obstructive. I think all of those propositions are true. And none of that should be of any surprise to us, because after all, lawyers and judges come from the society that we live in. They reflect the society that we live in and are part of, and are not, I think, expected to be different in any qualitative way from the society out of which we all come. And we reflect those values. So I think those who are thinking about social change and what role lawyers and judges can play and law professors can play in social change perhaps ought to think a little bit about the relative competence of lawyers and the legal system in dealing with issues. And this comment is going to reflect my bias, my background as a trial judge and a trial lawyer before that. Trials have a wonderful cleansing effect. They are a marvelous way of seeing big issues in a microcosm, seeing big issues brought down to human scale. And I think those who are interested in affecting social change through the legal system, and that's after all what the group here is interested in, needs to focus more than we have in the past on the value and importance of trials. Bear in mind that of the Brown case, when it finally got to the Supreme Court, and although it's referred to as one case, was actually 5 cases. And 2 of those cases were the product of trials. One in the Federal District Court in South Carolina, and the other in the Chancery Court in Delaware. That provided a record for what the Supreme Court did in the Brown case. And similarly, trials can provide a record, a grist for mills of social change. And I think in our discussion of the role that lawyers and judges play in social change, we've sometimes overlooked that value. It is a value added that I think is very important.
Thank you. Let me turn to a couple of the key kind of historical nodal points that liberals and progressives often focus on. They've been mentioned many times here. And let's start with Brown. And Olati, I'll turn to you. So you've written a good deal about Brown. So one view would be that now, with the advantage of hindsight, we are perhaps sobered a little bit in our view about what courts can actually accomplish. Do you think that the civil rights legacy has essentially been one of understanding the limitations of what courts can do, or, as is sometimes said, decentering the courts from the overall strategy?
Yeah. So good morning, everyone. So as I think about that question, and I think about the question you put to us at the beginning, I guess I would uncontroversially associate myself with the view that courts are catalysts in this process, but when we think about any kind of social change, we think about the role of political mobilization, we think about the role of the legislature, we think about the role of the executive. That said, I do think we tend to emphasize, maybe as lawyers, but I actually think more broadly in our society, the role of courts. I think we often tell a very sort of triumphalist narrative that leads inexorably to this moment in Brown where segregation in schools is declared unconstitutional, and a lot of people think that's where the story ends. And I'd actually correct Goodwin a little bit in saying that in some ways I feel like I write about Brown mostly to say that it isn't enough, right? To think about the courts that way or to think about social change in that way. I teach legislation, and I always begin my legislation class trying to correct the kind of common law-ism and the constitutionalist emphasis that students get kind of indoctrinated in first year of law school. And to think about what's the role of this other branch and what's the role of these other kinds of avenues for thinking about social change. Even so, the story I always tell that relates to Brown is that the 1964 Civil Rights Act, one of the provisions that a lot of people don't know about, but I think it was one of the most important provisions of the 64 Act, was Title VI. That says any entity that receives federal funds shouldn't discriminate, exclude, people should be able to participate. It applies to race, right? So why did Congress enact Title VI? It was actually a response. I mean, if you look at, I know we should be critical of legislative history, don't worry, but if you look at the legislative history, if you look at because it was actually a lot driven by the executive branch, you see that it was the concern that Brown had been bogged down in the courts, right? That school desegregation, they couldn't figure out how to actually turn this beautiful mandate, seemingly from the court with a weak remedial structure, into something that made a difference. So there's been a fair amount written on this about how, to the extent that there were changes made in school segregation, a lot of it was driven by this leverage that Title VI created, because school systems take federal funds, and they said you have to desegregate, you have to take affirmative steps. And so you look at that and you say, yeah, I mean, Brown was a catalyst. I mean, before that, you couldn't get, as David mentioned, you couldn't get a Civil Rights Act through the Congress. At the same time, there was a whole political movement going around, so I'm not suggesting that it was just that the 64 Act appeared without this sort of sustained political movement. You needed all sorts of different pieces to be in play, but I think oftentimes as lawyers, we don't tell ourselves this rich, interactive story that this legislative vehicle then helped prompt school districts, both in terms of voluntary compliance, but it also was a leverage point for courts when they were actually thinking about how to put remedies in place in school segregation cases. Having said all that, I guess the last piece I would have us think about, though, is that for me, the story then is always that we have to think about these multiple modes of change. I mean, I should add also the executive branch and New Deal executive orders and all of those playing a role in terms of desegregation. But it is hard in our society to completely decenter the courts. I mean, a lot of times when we do these great progressive legislative remedies, we find ourselves back in the court, either thinking about questions of, does Congress have power to do X and Y? Does this violate the Constitution, the equal protection rights? I think it's hard to completely decenter the courts. But I do think that we do have to think about this in a richer, more complex way than we traditionally have.
Great, thank you. Riva, let me turn to you. In addition to noting limitations about what courts can do, should we worry a little bit about producing sort of affirmatively negative consequences through the courts? And so that's a question that's been much talked about writers related to the backlash thesis. Let me read you something about Roe that you're familiar with. Justice Ruth Bader Ginsburg was at an interview with Jeff Stone at the University of Chicago not long ago, in which she made some remarks echoing, actually it was reported as news, but it actually echoes a view she has long held since at least the mid-1980s, which she wrote about in a law review article. She said about Roe, she said, the court should have held only that the Texas law before it in Roe was unconstitutional, leaving for the future the question of what other restrictions on abortion might be constitutional. She said her concern was that the court in Roe had given opponents of access to abortion a target to aim at relentlessly. My criticism of Roe is that it seemed to have stopped the momentum that was on the side of change. The court can put its stamp of approval on the side of change, let that change develop in a political process, but not more than that. You've written a lot about this subject, and I'd ask for your comment on this or any other broader part of the backlash thesis.
Well, in responding, I'm going to be talking about work actually that I started out doing with Robert Post and more recently have been doing on Roe itself with Linda Greenhouse, who's sitting right over there. So I guess we've heard, even in these most recent iterations, the concerns about Roe arising in the context of the question about marriage. And I would like to just cash this out really concretely and say that this is a cautionary aimed at progressives about the use of courts. You don't hear this about the ACA, the backlash story. I mean, in the sense of the court shouldn't go there because there could be backlash, or about affirmative action. It's really coming up in a class of cases. And so at stake is something like progressives' confidence and liberals' confidence in turning to courts. So the claim goes in this and other iterations that there's something distinctive about judicial involvement that triggers backlash by repressing politics. So in this version of the story or others, it's the court's decision in Roe that shuts down politics, represses politics, causes some virulent reaction, and what you get is counterproductive effects and electoral losses that progressives will regret. And with it also, if you just wait and use legislation, you could have the change that you would have had through judicial review. That's the whole of what we've just heard. And sometimes it's argued, ergo, you shouldn't use courts at all, or sometimes the cash out is you should use minimalist forms of adjudication. So what Linda and I did was research the period before Roe, book and article, and it's creates an opportunity for a science experiment because you're looking at the structure of the abortion conflict before Roe is in the picture. So you can't ascribe what's going on to the Roe decision itself. And I'm going to just talk very briefly about two forms of opposition to the movement for liberalization of access to abortion that are escalating quite sharply before Roe is coming down. One is Catholics who oppose even incremental legislative reform that, for example, involves protections for women's health or against rape, as an exception to criminal abortion laws. This trips off counter-mobilization against legislative change and with a fury, actually. It suggests that when you unentrench traditional status relationships of various kinds, you're going to get reactions to the change itself regardless of the moving cause. These were state legislative decisions. A second source of pushback that begins in the pre-Roe period is not an anti-abortion movement itself, but rather within the Republican Party, there comes to be, and in the Nixon White House even, there comes to be interest in changing course on abortion in order to recruit voters to the Republican fold, specifically Catholic voters and also social conservatives. And this begins, again, before Roe comes down, illustrating in interesting ways that once there's a conflict at foot, the normal, healthy operation of politics gives incentives to political actors to engage and take positions in that conflict in an effort to maximize political advantage. So you see both of these dynamics in the period before Roe. I should emphasize also that this is going on in a period of rising public support for decriminalization. And the court that decided Roe had Blackmun's papers, had a Gallup poll showing supermajority support for the idea that a decision on abortion should be left between a woman and her doctor in August of 1972. 64% of Americans supported this. A majority of Catholics supported this, and more Republicans than Democrats supported this, which is the world before the opinion issues. So I put those facts out there. I just wanted to add something to this briefly, which is to say, not that this settles all of the question, but it should make us more cautious of stories that suggests that courts alone are causing the forms of pushback that one encounters. It suggests that certain forms of deep disruptive change elicit both defenders of the status quo to move forward, and if it's on an identity issue, it's going to really have certain groups exceedingly mobilized. That's a race story there, if you want to think about it there. It's the religion and sexuality story today, if you want to think about that one there. Also, that there are going to be others in the political system who will want to take advantage of it, and all of that just points to the notion that conflict may be inadvertible, no matter which way you go, legislatures or courts. What the court did was do an unlocking. You know, there was a lockup in this earlier period. I should have said this about Ginsburg's claim, I suppose. I should offer these facts. Because of Catholic mobilization in the period just before Roe, while there had been a surge of reform, it stopped by about 1970. And between 1970 and 1972, there were 12 states that tried liberalization, none of which the claims went through. I mean, the legislation went through. It was minimalist legislation, actually. This actually meant that the court was acting in a majoritarian direction when it decided Roe. So that's something courts can do. They also give visibility, and I think also in important ways allow for shifts in the meanings of particular claims socially. So there are benefits. So the bottom line here is that there's going to be something like a cost-benefit calculation in making decisions, and it's not it's not an argument to be indifferent to backlash, but rather a caution that by avoiding courts, you're going to somehow or other avoid it. What you may be doing is slowing down the cause of change in a very dramatic way. And I guess I can end this by saying that a decision like the decisions in the marriage cases that we've looked at recently, while they create pushback, they also have been enabling legislative change. Many of the Goodrich, the northeastern states that eventually adopt marriage legislation did so after litigation. And so there are roles that court decisions are playing that are helping shift the public understandings and group connections in a way that can't make change by itself, but is an important engine of change.
Terrific, thank you. Nick, let me bring you into the conversation as well. I'm curious if you have any response to Jack's claim that the living Constitution is alive and well, but mostly on the right. And in particular, something we haven't talked about yet, which is the role of Article 5 of the Constitution, which lays out the formal process by which these changes in constitutional understanding are to be achieved.
Yeah, I'd be happy to talk about that. Thank you for having me here. Goodwin was actually too polite to point out in his introduction, but I'm actually on the Board of Visitors of the Federalist Society. I think my role here is meant to be as a foil, so I'll try to fulfill that role. I can tell you, your convention looks a lot like our convention, and that's I bring you, greetings from the Federalist Society. We take that to be the sincerest form of flattery, so we're happy about that. But I think my role is to be the textualist on the panel, and so I began with the text of the title of the panel from your brochure here. Everyone's spoken about the courts and social change, but the title actually is the courts, the Constitution and social change. And so I thought I might try to interject a few thoughts about the Constitution and the role that it might play here. So the first thing I really want to remind us of is it's at least theoretically possible that the social change you want is inconsistent with the US Constitution across some dimension. You must believe that unless you believe that the Constitution just definitionally coheres with all of your policy preferences. And so you have to acknowledge the possibility that the social change you desire is maybe inconsistent with the Constitution, whatever is your theory of interpreting the Constitution. And I'm just going to give you a kind of a trivial example just for you to think about. It actually, I think it's in Goodwin's book, this example. Consider social change, consider a very basic form of social change, inflation. So this is a social change that we can all agree is kind of inexorable. We're going to actually, you can measure it. You can actually measure it. It's quantifiable, mathematical. The Seventh Amendment specifies jury trial in cases where the amount in controversy is above $20. Now, this is perhaps the easiest case for a living constitutionalist because it'd be very easy to update that provision. Very easy to just, as a matter of math, say, well, they said $20, but they really meant some de minimis amount, and if we do the math, the $20 is really $20 then is $600 now or whatever, and so we should just interpret the 20 to mean now 600. And you'd think that it'd be almost the least controversial version of living constitutionalism because it's so mathematical. We can actually just all agree that 20 then actually equals 600 now. And yet, though, I don't think anyone thinks we should do that. I think actually we probably have unanimity here on the panel that courts shouldn't be in the business of translating the 20 to the 600. At least Goodwin doesn't think so in his book. So I know I at least have one ally for that. I think maybe...
Did I say that?
I think so. So I think maybe we have consensus on that, and if we do, or if you can think of any example for yourself where you think some social change is actually inconsistent with constitutional text, you have to acknowledge the possibility that the Constitution might stand in the way of the social change that you are talking about. Now, I'll just, again, kind of remind you of the very basic jurisprudential debate between textualist originalists and I guess living constitutionalists, and where this fits within that debate, the very basic moves, right? The originalist textualist says we should interpret the Constitution per the original public meaning. And then the living constitutionalist says, well, but if we were to do that, we would be governed by these dead white men of 2 centuries ago, and first of all, they could never have imagined modern society and modern technology and so forth. and moreover, maybe they had really benighted, social views and could never imagine our, more enlightened views, I guess, could be a response. And to that, the originalist or textualist has a lot of possible answers. But the one I want to focus on that you hear often is, well, okay, maybe that's right. Maybe that's right. The framers could not have imagined all this. But they were aware of the possibility that they couldn't imagine all this. And so out of the 7 articles of the Constitution, they wrote in one that provided for constitutional change, which is Article 5. So they acknowledged the possibility that maybe society was going to change in a direction that was going to be inconsistent with constitutional text. And they have a method for actually changing the Constitution to cohere with social change. So, I suggested I was going to maybe talk a bit about Article 5, and Goodwin said, that'll be interesting. We never talk about that. But the truth is, progressives used to talk about it. Progressives actually used to talk about Article 5. Indeed, they successfully passed 4 constitutional amendments in a period of 7 years, from 1913 to 1920. And, progressives used to think in terms of, when their social goals were not consistent with constitutional text, actually changing the text to match what they thought the Constitution ought to say, rather than urging judges to interpret the text to mean what they sort of want it to mean. They actually, went through the Article 5 process. And the only other thing I want to say about that, so, I guess I want to invite you all as progressives to consider that strategy. And consider that your sort of progressive forebears, actually took a look at Article 5 for constitutional change rather than looking to the courts necessarily for social change. The last point I want to make about this, a traditional answer, so the originalist says, if you don't like it, change it. See Article 5. And the progressive often says, yeah, but that's really hard. It's really hard to do. It's extremely hard to do. I want to say it's actually not that hard. It's been done 27 times, and that's, it's about once every 8 years, and the progressives were hugely successful at it in a span of a short period of years. So it's not, it's not impossible. It has been done. And then I'll just draw your attention to one example I think is worth thinking about. Consider the 18th Amendment, prohibition, right? The Prohibition Amendment. There's a couple lessons we could learn from that. One lesson that, we could possibly learn is, that history's not actually kind of inexorable parade in the direction, led by progressive elites in a particular direction. Actually, there have been some, missteps and some, turns 180 degrees and so forth. So, I think that example could maybe give us a tiny bit of humility about the project of entrenching, our vision of social change. Another thing, though, is I think it actually is a clue that the Article 5 process is just about right. So, if you're sitting down to write a constitution, how hard would you make it to amend the Constitution? You might ask yourself that question. I think it's very hard to know. It was very hard to know back then whether 2/3 was right, or 3/4, or 7/8, or how even to think about that question. But, a good piece of ex post evidence is how many disastrous amendments have there been? And, or how many needed to be repealed within 15 years? And I guess I think if there were lots of such examples, that would be a signal that it was much too easy to amend the Constitution. But I think that if there were none, that would actually be a signal that it was too hard. So, I think it's actually interesting that we have this kind of one case where the progressives, successfully amended the Constitution and was successfully reversed within 14 years. I think that suggests that the Article 5 process kind of works and has, has been a sensible constraint on some progressive social change, but has also allowed for some kind of dramatic progressive social change. And I guess I would just invite you all to consider the Article 5 strategy that progressives, used to such great effect in 1913 to 1920.
Thank you. I was thinking that, if you were in a place where there's a lot of constitutional change that occurs through the formal process and then gets repealed, it wouldn't mean anything except for the fact that you live in the state of You know, Nick, it really is a sign of really how gracious you are. You're probably the only member of the Federalist Society that has read our book. And I think you make a couple provocative observations, which I'll put to the rest of the panel. Anybody would like to respond? One, I think you make the interesting point that there must be some social change that is ruled out by the Constitution, or at least the Constitution as it exists, if it's not going to be amended through the formal process. So I'd like anybody who'd like to respond to that. And then secondly, what about Article 5? Shouldn't that be the proper pathway to change, and one that liberals and progressives should embrace? Jack, you look like you're chomping at the bit.
I was just thinking, Nick and I both start from the proposition that we think that we should be bound by the original public meaning of the document. But Nick left out a very important feature of the original design. The framers of the Constitution did not simply rely on Article 5 as a means of dealing with change. They actually had two other basic structural elements. The first is that they used different kinds of language for different kinds of legal norms. So, for example, they had certain hardwired rules, how long the president's term is, but they also had deliberately used language which was in the form of abstract principles and standards: reasonable searches and seizures, freedom of expression. The later Reconstruction framers, if you look at the 14th Amendment, you see the same thing. There are certain things that are hardwired. There are certain things that are done in terms of principles and standards. Now, the reason they did this was exactly what Nick said, which is they understood that they did not understand everything that would happen in the future. And they believed that it was necessary for subsequent generations to build on the work that they only began. You must remember, they understood themselves as engaged in a great experiment. Nothing like the American Constitution had ever been attempted before. Some things they got right, some things they got wrong. They didn't predict the party system. They actually didn't predict Article 5 correctly, because, in fact, we have a natural experiment with constitutions. It's in the United States. There are 50 state constitutions. No state constitution has requirements as difficult as the American Constitution. There are, by now, several hundred constitutions written around the world. No constitution around the world has an amendment process as difficult as the United States. The United States Constitution was the first attempt. They got that one wrong. It turns out that Article 5 is not, in fact, the ideal one. It would be extremely surprising if on the first attempt at writing a constitution for a federal republic, they got it exactly right. And indeed, the ratification of the Constitution itself doesn't conform to the Article 5 process. If it had, I suspect we might not have had the ratification of the Constitution. So the point I'm simply making is this, that the framers understood their own limitations. They were men who were very wise, but part of their wisdom was understanding that much of the work of the Constitution has to be done by later generations. And that's why when we interpret the standards and principles in the Constitution, we can say that we are being faithful to the basic plan itself. That if we say that we may only interpret and construct in the way they would have interpreted and constructed, we are engaged in a false kind of humility. We are, in fact, disobeying their view, which was that we have a duty in our time to make sense of the great principles that they placed in the document. That is what a living constitution is. It is something that's been pursued not only by the left, but by the right. And the achievements of constitutional jurisprudence on the right in the last 25 to 30 years are a remarkable example of how you take a principle like freedom of expression and turn it into a protection of a particular right, in this case, the right of money to influence the political process. This is a form of living constitutionalism. We should understand it in its own terms as a debate in our generation about how to make sense of the document.
Nick, I'm going to give you a chance to respond, but Riva and David have a couple comments first. So Riva, David, you're gonna have to. that's the problem with being the one. So
I guess I'll just say that your convention looks a lot like the Federalist Society convention, but I will tell you that our panels are not 6-on-1. So you might actually consider the possibility of a bit more balance on this one.
I'd be happy to do one-on-one with you.
Fair enough.
Okay, Riva, and then David, and then Nick.
So given the lineup here, I'll be really brief, just to say that the framers, if we want to start with them as authorizing a conversation which is many participants, the framers created many forms of openness in the Constitution, one of which is Article 5, another of which is the use of open-ended statements of principle in some context. Another you could point to is the appointment of judges through a representative process. So one could point to these different points of openness and understand Article 5 as an intended vehicle of change, but there's nowhere in the document that says it's exclusive. That you actually have to read in. When we look at Article 5, and this was the main thing that I wanted to bring to folks' attention, it works not only by completed amendments, but also by incompleted amendments. That is to say, by amendments that are initiated, but never wholly formally ratified. And in observing this, we can say that the Constitution is creating points for openness, for popular response to change. And with that as a vehicle, it's created opportunities additionally for conversations with the court. I've written about one example, which is the ERA itself as a spur to the rise of the sex discrimination cases in the 1970s, with the fight over the ERA being a locus for not only progressive but conservative voices about the meaning of equality in the family. But I'll just to end this off, say that you can think of many other examples, many famously from the 70s, for example, anti-busing amendments and Milliken, the Human Life Amendment, and Harris and McRae. You can think in our own day of the federal marriage amendments, as all of these being opportunities for opening conversation that have been very powerful in shaping constitutional meaning.
Yeah, and before, not to pile on Nick, but I would
This
just...
isn't a pylon.
No.
This is in veneration of Article 5.
It's in veneration of Article 5. It's another example of openness, obviously, is Section 5 of the 14th Amendment, I think, which puts forward this view of what is it that the Constitution restricts and what does it allow is often what's very much at issue. So in Section 5, the enforcement clause says enforce the substantive equal protection guarantees of the 14th Amendment. What does that mean in terms of the reach of Congress's power? What does equal protection mean? Who defines it? I mean, all those are left fairly open.
And then I'm going to move on to some contemporary controversies in a second.
Yeah, again, I also don't want to pile on Nick, he says, proceeding to pile on Nick. I think I also want to sort of highlight something that I think all of us should be thinking about, both progressives and, for that matter, the sort of conservatives in the room, which I think are probably like one, which is a couple of things. I mean, I think the Article 5 is just not the way we change the Constitution in our system. It's just not. And that, no doubt, is because it's so hard to use Article 5. We have lots of well-developed means of changing the Constitution. Article 5 just is not one of them. So here are a couple of data points. There are many that I could offer. If you think about major constitutional changes, and they have to be called constitutional changes, in the 20th century, the expansion of executive power, particularly in the area of foreign affairs, the expansion of legislative power over the economy, the federal legislative power over the economy, the growth of the administrative state, the expansion of the rights of racial minorities, the expansion of the rights of women, possibly the expansion of the rights of gays. Not one of those was accompanied by a constitutional amendment. The 19th Amendment enfranchised women, but discrimination against women by public agencies continued for a couple of generations after that. And it changed despite, as Riva mentioned, despite the rejection of a constitutional amendment, the Constitution changed anyway in pretty much the way the rejected amendment would have changed it. When you see that, you just have to say, look, amendments are not where the action is. One other data point, which I think makes the point, if you just picked up the Constitution and read the amendments naively, you would say, oh, I see, you all enfranchised blacks 60 years before you enfranchised women. That's interesting. Of course, that didn't happen. an amendment was passed purporting to enfranchise blacks. It operated in the North where there weren't very many blacks. It was very quickly nullified in the South, and it took another century before blacks were actually enfranchised, whereas the enfranchisement of women proceeded fairly quickly after the 19th Amendment. What does that tell you? It tells you the principal engine of constitutional change. If you want to look for it, you got to look outside the text. I think a deeper point here is that the sort of emphasis on the document and the framers, I think, is just mistaken. When you're running a complex society that spans a continent, you've got to take advantage of the wisdom of more people besides James Madison and the boys. You've got to take advantage of the wisdom of John Marshall and Abraham Lincoln and Theodore Roosevelt and Franklin Roosevelt and Martin Luther King and Thurgood Marshall. Their wisdom also has to play a role in the Constitution. And it's a mistake to try to tie everything back to the framers. That's just not the way any complex and mature society works. And I think to the extent you try to do that, you're operating in a way that conceals from yourself and from your movement the real mechanisms of constitutional change.
Nick?
Well, I guess I just have to disagree that the action is not in Article 5 or that it's somehow impossible. It has actually been amended 27 times. Now, there's... Oh.
No, I wasn't mugging you.
I think I just want to disagree with that. There have been hugely important constitutional amendments over time. So, I think I just want to disagree with that. And then I'll just, offer up a question, really. Consider the ERA story, and Riva knows much more about this than I do, but at least a story is that the ERA would have been ratified, but for some dramatic changes in doctrine at the Supreme Court. And I would just pose as a question: is that good news or bad news? Is this a happy story from your perspective? I mean, I guess my instinct is it would be better if the ERA were on the books than for these changes to have happened via judicial decision. And it's an honest question. I don't know how many people in this room agree with me about that, but if you do agree, or even if you think it's an interesting question, that should give you a bit of pause about the courts getting ahead of actual Article 5 constitutional change. Should make you a little nervous about it, maybe.
Okay, let me...
Can I just one sec? I want to say that I find that view quite compelling, but to the extent I understand the history, it's an interesting case of counter-mobilization having started in a way that was probably going to produce a lockup there, too. And that's a complex, reconstructing the facts, but it's not so clear that it would have transpired that way.
Let me switch gears a little bit in terms of the focus of our discussion. We've been talking a little bit about history, and though it is contested, of course, we have great benefit when we look at history of hindsight. I want to switch gears to contemporary controversies and controversies that are before the courts right now. And that's harder because we don't know how it's going to turn out yet. So courts can issue decisions. We can all gather up again at the 35th anniversary of the ACS conference and think about how it all turned out. But looking at things from right now, the question is, what should courts do? So let me put in front of us perhaps one of the biggest issues, the same-sex marriage case, and we have a little audio clip that I want to cue up, which will be provocative and sort of frame a little discussion. So, John, can you play the audio? This is from the oral argument.
Right into a question I was going to ask. The California Supreme Court decides what the law is. That's what we decide, right? We don't prescribe law for the future. We decide what the law is. I'm curious, when did it become unconstitutional to exclude homosexual couples from marriage? 1791, 1868, when the 14th Amendment was adopted, sometime after Baker, where we said it didn't even raise a substantial federal question, When did the law become this?
I may answer this in the form of a rhetorical question. When did it become unconstitutional to prohibit interracial marriages? When did it become unconstitutional to assign children to separate
Easy question,
schools?
I think, for that one. At the time that the Equal Protection Clause was adopted. That's absolutely true. But don't give me a question to my question. When do you think it became unconstitutional? Has it always been unconstitutional?
When the California Supreme Court faced the decision, which it had never faced before, does excluding gay and lesbian citizens who are a class based upon their status as homosexuals, is it constitutional?
That's not when it became unconstitutional. That's when they acted in an unconstitutional manner. When did it become unconstitutional to prohibit gays from marrying?
Then they did not assign a date to it, Justice Scalia, as you know. What the court decided was a case that came before.
I'm not talking about the California Supreme Court. I'm talking about your argument. You say it is now unconstitutional.
Yes.
Was it always unconstitutional?
It was constitutional when we, as a culture, determined that sexual orientation is a characteristic of individuals that they cannot control.
I see. When did that happen?
There's no specific date in time. This is an
Well, how am I supposed to know how to decide a case?
Because the case that's
you can't give me a date when the Constitution
case that's before you
changes.
today, California decided, the citizens of California decided, after the California Supreme Court decided that individuals had a right to get married irrespective of their sexual orientation in California, and then the Californians decided in Proposition 8, wait a minute, we don't want those people to be able to get
So
married.
your case would be different if Proposition 8 was enacted into law prior to the California.
I would make
Okay. I think Justice Scalia is about to explode at the end of the series of questions. So I put that out there because we can all kibitz about in 20 years, what the proper answer to that question was. But somebody has to answer that question right now. And so I guess I put to the panel, Judge Walker, since you have your hand raised, how would you answer Justice Scalia's question?
Well, one way that Ted Olson could have answered the question, but in a way he's too good a Supreme Court advocate to have used this, he could have said, Justice Scalia, it became unconstitutional in June of 2003 when you dissented in the Lawrence case, and you said if Lawrence has decided the way that it is, then that dismantles any basis upon which to discriminate in marriage on the basis of sexual orientation and so forth. But Olson pulled his punch, and he didn't use that line. And of course, another answer that could have been provided is that when the government, both state governments and federal governments, started granting favorable treatment to people who were married, it no longer became feasible and constitutional to withhold those benefits on the basis of the genders of those who were in those unions. And of course, the answer that he attempted to give, and gave as well as he could, I think, under the circumstances, is that our understanding of these principles in our Constitution is not defined in any timeline. It is a process of evolution, maybe a living Constitution, the word that Justice Scalia doesn't like, but nonetheless, there are a lot of answers to Justice Scalia's question. Maybe not the best answers were given in the oral arguments in the Supreme Court hearing.
Anyone else? How would you answer the question? Nick?
Yeah, I actually think Justice Scalia is on to a really deep and important idea here. So Justice Scalia is on to the when question. I've written an article called The Subjects of the Constitution, trying to think about the who questions in constitutional law and the when questions in constitutional law. Again, with kind of careful focus on text. When you think about it, certain provisions of the Constitution are written to bind legislatures by their terms. That's who they are addressed to. For example, the First Amendment says Congress shall make no law. So I claim, kind of radically, I guess, for this audience, Congress shall make no law. I claim that clause is about Congress. It's about Congress. and it's about the making of law. So the answer to the who question in the First Amendment context has to be Congress. The answer to the when question in the First Amendment context has to be the moment when they made the law. And it follows then that facts or social changes, or really facts of any sort, after that moment kind of can't be relevant to the constitutional inquiry. It's either Congress violated the First Amendment on that day or they didn't. It's my claim for the First Amendment. Now consider the 14th Amendment's a bit trickier. So 14th Amendment, no state shall make or enforce any law. And I say, well, so it sounds like that clause binds both the state legislature making the law and also state executive branches from state executives from enforcing the law. You know, consider why they had to write it that way. There were already discriminatory laws on the books, right? They couldn't have just said no state shall make any law, because a state could have, Alabama could have just enforced its pre-existing law, said, well, we're not making any, right? So they had to say no state shall make or enforce. I suppose you could say that what's at issue, you know, a possible answer to Justice Scalia could have been, I'm protesting the enforcing of this, which just happened recently and maybe turns on some new facts. You know, but the inquiry requires you to ask yourself, who are you really complaining about? Are you complaining about the legislature that passed this law? Or are you complaining about the executive enforcing it? And it might actually change the substance of the inquiry. So I actually think Justice Scalia is on to quite a deep, important constitutional point.
David?
I kind of want to agree both with Nick and with Judge Walker that this, on some level, is an interesting and deep question, but for purposes of the issue before the court, there's much less to it than meets the eye. And here's why I want to say that. Here is one, I think, totally undeniable fact, that the accepted answer to the question, what is the law on this subject, that changes over time. If you're thinking about what you got to say to pass the bar exam, or what's going to get you Rule 11 sanctions in court, or if you're a public official, what to subject you to damages because you haven't satisfied the qualified immunity test. If you're thinking about that issue, the answers to those questions change over time. And the answer to the question, is segregation in the public schools constitutional? That was different in 1910 from what it was in 1960. The answer to the question about different pay scales for men and women was different in 1940 from what it was in 1980. And there's just no way around that. If you're worried about passing the bar or you're worried about not getting Rule 11 sanctions. Now, if you want to say, well, okay, is what happened in that interval, did we rediscover what was there all along, or what was there all along changed? Now, you could argue about that. I actually think the idea that this is all a process of archaeological discovery of what the framers, in some sense, always publicly meant, I don't get that. But okay, we could have that argument. But it seems to me that for purposes of the case, it is just a fact of American law that what the law is in the practical common sense ways I described, that changes. The mechanism of the change, that raises some interesting questions, interesting theoretical questions, but the fact of change, I think, is undeniable in American law. And for that reason, I think the sort of issue that Justice Scalia raises, if it pleases him to say that whatever the Constitution now means, it always meant, fine, he can say that. That seems to me a little odd, but he can say that, as long as we can agree that we make progress in these dimensions by changing what the law is.
Let me put another, I invite other responses to that question, but let me put another issue on the table, a contemporary issue. We're expecting a Supreme Court decision in the next couple weeks on the Fisher affirmative action case. That's an issue on which I think many people on the progressive side have noted that the originalist thesis about the 14th Amendment is noticeably absent. And there's not much excavation of the original meaning of the 14th Amendment when the justices go about deciding whether affirmative action is or is not constitutional. But this is an issue on which there's also been significant social change. In the past couple decades, I think it's fair to say public opinion has shifted significantly to the negative on this issue. 8 states have banned discrimination, have banned affirmative action in order to achieve equal protection of the laws, and the Supreme Court has been narrowing the window. What should those surrounding social circumstances, that's sort of the inverse in the progressive world at least, an inverse of what we've observed on the issue of same-sex marriage. What role should those kinds of observations of changed circumstances play if we're not wedded to the original meaning of the 14th Amendment.
I mean, maybe I'll jump in on some of this, and I'm sure others have reactions. I mean, I think one on the Scalia question, it makes me actually very thankful that I don't teach con law, because constitutional methodology always confounds me in the sense of it, for someone who's kind of an outsider to the debates, it raises a lot of questions. It makes you skeptical. I mean, so the example, when Scalia says at that moment, well, school segregation or interracial marriage was always unconstitutional, you think, well, so at the time of the 14th Amendment, segregated schools, no, there wasn't public conversation that suggested it was unconstitutional. And then as Goodwin just suggested, affirmative action, there were race conscious, or at least sort of reparations, remedies for slaves that had race conscious elements for former slaves at the time of the 14th Amendment that didn't provoke scrutiny, that no one thought of as being a problem. So it makes one wonder how one should think about these kinds of questions, but I'll leave that to the constitutional theorists. I mean, so when I think about the question of Fisher and affirmative action and public opinion, I mean, I'll just note that, yeah, in some ways, public opinion has never been overwhelmingly in favor of any racial remedy that I can think of. And so that can't be a satisfactory reason not to have a racial remedy. But I would fight the notion a little bit that affirmative action is unpopular because it's quite widespread in a lot of institutions, in higher education institutions, in government institutions, obviously famously in the military. And a lot of schools rallied around the notion that they wanted an admissions system that they think of as being fair in particular ways. I think they could all do more on different fronts in terms of intergenerational equality, in terms of economic and class equality. But a lot of institutions have something like holistic admissions, where in considering the backgrounds of various students and assessing what we mean by merit and qualifications, they consider a range of factors in which the experiences of people or obstacles people have faced that may or may not be connected to their race, ethnicity are a factor. And I think that that's how a lot of institutions would characterize it. I think it's unclear what the court is going to do with that. I'm not going to make predictions. I know that they've mostly been pessimistic because it doesn't take this long to write an opinion upholding the lower court opinion. But I will say, just as a way of, I think that a lot of the cases that are on the court's docket actually raise this question of the interaction between public opinion and the court. So, I mean, you can think of the Prop 8 case in that way, as a case in which public opinion said one thing in the state of California, and there's a real question out there as to what the Equal Protection Clause is going to allow. There's another affirmative action case that's coming up that some of you may know about, where Michigan bans affirmative action through its direct democracy process, and there are questions raised about whether that, under the same doctrine that would be at issue in Hollingsworth, raises equal protection problems. And then I think the voting rights case is another case in which this sort of tension comes up, where another quote you could have played by Scalia is where, in the context of the argument in the voting rights case, he almost cites it as a problem. That it was passed so overwhelmingly unanimously. This shows that nothing, except for that Congress wasn't really critically evaluating the racial costs. This is just racial entitlement. So I think there are a bunch of different cases that, interestingly, raise the question of this interaction between sort of what we think of as being sort of what popular majorities want, and what is it that the Constitution requires, and they don't all lead to the same place. I don't think they give us any deep kind of theory of where we should end up on that. But I just raised that as something to think about, that it's not a very clean relationship when we think about the interaction. But I didn't know if Jack wanted to say something on the broader, okay.
Let me continue the conversation. I'll put one more issue on the table. This is a question from the audience. Gun rights. So the question is Heller an example of conservatives using social movements? The whole engine professors, civil society, litigation campaign, the whole engine of society used to change constitutional interpretation. This is something, Reva, you've written something about. Should we be accepting, skeptical, or skeptical about that phenomenon? Or does it matter that the Supreme Court ultimately didn't couch the decision at all in these terms, but instead both sides of that decision were highly originalist in their methodology?
Well, I guess the first thing I want to say is that we could spend the rest of the time we have talking about what we mean by originalism here. But one form in which I want to invoke originalism is as a political mobilization that beginning in the 1980s began to make claims on the founding as a way of criticizing the work of the Warren and Burger courts. And if one understands originalism as having grounds in politics and not just in courts or in academies, one can see that originalism helped facilitate not only mobilization around issues of church and state, family issues, the abortion issue, but also the gun issue. But it also functioned as glue for the Republican Party in the sense of putting together coalitions of groups that might not have understood themselves as connected, but came to understand themselves as opposing an overreaching court. And that gave them a language for understanding identity and connection. And so one can see originalism here as connected to mobilization and to the operations of executive branch constitutionalism. And that seems an important way to understand it. Then when you go to the gun case, I could make the observation that there is mobilization around gun rights that is prompted in the 1960s and 70s by gun control, but also in part in opposition to the civil rights movement. That is to say, there's culture wars entangled here, so the idea of mobilizing for, seeing the conflict between citizens and criminals and asking for the rights of law-abiding citizens to defend themselves is the language of the late 1970s. Much of this finds its way into Heller via, among other things, judges appointed by the Reagan administration. The early decisions beginning to first find a Second Amendment that would constrain gun control were first authored by judges on who had been appointed by Reagan. And what does one see in this? One sees, now it sounds like this could be a large critique. And I'm going to just pause and say, in the spirit of this panel, something like a living constitution that is articulating a relationship between past and present. It's not acting with indifference to the founders, founding sources, and otherwise, although if I had the time, and I won't take it, we could have an argument about whether Heller is faithful to the best understanding of the Second Amendment's ratification history. That's what Stevens is talking about in the opinion. I don't know that I'd call that originalist. I can say he's making claims on historical sources. But it's also infusing it with values and meaning of living Americans. And so in answer to Justice Scalia's question, the when is sometime in the late 20th century, not just in the 18th century, did the Second Amendment begin to constrain gun control laws.
Nick, go ahead.
Yes, I guess I'll just say, as to your question about affirmative action, it's a great question. It just it should remind you all again that the movement of history is not in this kind of inexorable progressive direction, consistent with what your policy preferences might be. And if you believe that the poll numbers should be relevant to the constitutional question of, say, gay marriage, you do have to have a story about what you're going to do with the poll numbers as to something like affirmative action. Now, for me, those poll numbers are strictly irrelevant to both constitutional questions. But for you, I think you do. If you think they're relevant to the one, I think you have to think they're relevant to the other, and you have to explain what you're going to do with that. So I think it's a provocative and excellent question. Now, to me, they're irrelevant. So to me, they actually don't belong as part of the constitutional inquiry. I'll just circle back around and say to Jack, I quite agree that some provisions are much more open-ended than others, and that the framers certainly embodied or allowed for social change via more general language. So I think a great example is the unreasonable searches and seizures, which you can apply to heat-seeking, or heat sensors and so forth, DNA, whatever. But even these very open-ended provisions may well have a kind of core meaning. It doesn't quite follow that any interpretation will work for any clause. I would say of the Equal Protection Clause, I'd say this is quite an open-ended clause, and very hard to figure out quite what categories should be suspect, and quite what was forbidden and what wasn't, as a matter of text, as a matter of history. But to me, the affirmative action case is the easiest possible case. So, whatever you think might be at the edges of this clause, to me, the core idea was we're not going to have government discriminating on the basis of race. We're not going to have the government saying, you cannot come to our university because you're not the right skin color. And, I think actually that's, for text and for history, we don't actually have to go too much further than that. To me, that's like the $20 case, actually. If you'd like a prediction, I think the court is going to strike down what Texas is doing, but I think it'll be very narrow, and I think you'll see it's not going to strike down affirmative action globally, it's just going to strike down what Texas is doing.
Jack, since your name was invoked, I'll give you the last word.
On this, I just want to say that this is actually not what the history of the 14th Amendment was about. You remember that in the Committee of 15, they specifically considered a colorblindness amendment. It was rejected several times. They specifically had to have a 15th Amendment because they did not want to give blacks the vote through the 14th Amendment. The basic principle under the 14th Amendment was not colorblindness. Nobody thought it was. Certainly Thaddeus Stevens wished it would have been, but he lost. And in a famous speech he gives at the end, he says, I didn't get everything I wanted, but maybe in someday I'll get everything I wanted. What they thought, to go back to this idea, the core idea is a ban on what we might call class legislation or caste legislation. The class legislation is legislation which picks a group out for special burdens or benefits without adequate public justification. And caste legislation is legislation that uses law to subordinate a group of people in law. This was what they thought the central issue was. They disagreed with themselves about what would be class legislation or caste legislation, but that's the basic principle. The issue in Fisher, I agree with you, I think that they're going to narrow Grutter. I don't think they're going to overturn Bakke. But the issue in affirmative action, and you may have different views about it, is the question of whether or not the ways in which we distribute opportunities to have opportunities, which is really what contracting and education are about, whether these are in fact unjustified by any substantial public purpose, whether they unfairly take a group of people and impose a special burden on them, which is unjustified, and whether they take a group of citizens, white citizens for example, and subordinate them through law. You may have interesting debates about how you think these principles apply, but I think it is far from clear what the framers of the 14th Amendment would have thought about these questions.
Can I just say one thing? The court also has played a role in shaping public opinion around these questions. I simply, I don't think it's just a reflectionist story that we're telling here. And the court's rulings on this question have also, I think, played a role.
Okay. It's 11 o'clock. I'm glad we've settled everything in this panel. I have some concluding remarks before sending you off to the next panel. But before I give those, please join me in thanking the panelists for a very stimulating discussion. So I've been to a lot of ACS conventions. It's Saturday. Your mind is completely saturated. You're swimming in lots and lots of different ideas. A couple of conventions ago, I gave the following advice for how to leave here with a good convention under your belt, and I'll give it again. There are 3 things you should do. The first is you should make sure you walk away from this convention having met someone that you wanted to meet. Okay? I mean, there's a lot of legal rock stars in the room. Make sure you meet someone that you wanted to meet. Second, make sure you come away from the convention with one idea that you didn't have before. Shouldn't be hard. There's lots and lots of ideas here. Come away with one, pay attention. And then the third is, think about one thing that you're going to do after the convention. So I'll give you my three-point synopsis for myself. I met Beverly Martin from the 11th Circuit, who I had wanted to meet because I had read an opinion of hers regarding sentencing, which you all should read as a separate opinion about judicial deference to upward versus downward sentencing, departures in the sentencing guidelines. One idea, I thought I was very provoked by Justice Stevens's observation that things actually got worse for the disproportionate apportionment of voting in the South after the 15th Amendment than it was before. And the one thing that I'm going to do is I'm going to build that idea or use it in a questioning way the next time I teach constitutional law. So I would urge all of you to just, think about that. And so, at this point in the convention, this is where, you've been here for a while. We separate the groupies from the diehards. Those of you who are still here are the diehards. The breakout sessions that follow this panel are the following. So let me just direct you. Comprehensive immigration reform is in the Federal A room. Winner stay, loser pays, developments and fee shifting are that one's in the Federal B room. National security and the war on terror, that one's in the South American room. And the era of mass incarceration is in the Senate room. Okay, thank you all for being here, and hope to see you next year.